Okay, so I think we can make a start. My name's Emma Conwell. I'm a senior associate in the planning and environment team at Walker Morris. Today, obviously, you've joined us to talk about biodiversity net gain. So we've got quite a good session planned for you. First of all, Alison will be covering biodiversity net gain from a legal perspective on behalf of Walker Morris. And then we've got Paula Carney, who is a director at Carney Sweeney Planning Associates, who will talk about the practical side, some new case law and some recent policy decisions in relation to biodiversity net gain. So first of all, we're going to kick off with Alison. Alison's a partner in the team here at Walker Morris, and she'll kick off proceedings. In terms of a bit of housekeeping before we start, if you have any questions as we go along, please could you use the question and answer function, which is on the right-hand side of your screen. If you type your questions in there, I can collate them and then we'll pick them all up at the end, because at the moment everyone's muted, so we can't hear you, but I'm sure you're all smiling and giving us thumbs up through the screen. So if you could pick up that Q&A function, that'd be really helpful. So I'll hand over to Alison now to make a start.
Oh, good morning, everyone. Thanks very much for joining us to discuss biodiversity net gain. As Emma said, I'm one of the partners in the planning and environment team here at Walker Morris, and this is a topic that I'm seeing obviously coming up again and again, particularly at the moment. It's a really hot issue for lots of developers, local planning authorities alike. I'm going to start by running through some of the background and the origins of biodiversity net gain. So really the legal framework for biodiversity net gain comes from the Natural Environment and Rural Communities Act, which tends to be called the NERC Act, and it places a duty on decision makers to have regard to the purpose of conserving biodiversity. Now, one of the things that's going to change as a result of the Environment Bill in connection with biodiversity net gain is that the duty is going to change. So it's now going to become conserve and enhance, and I'll pick more up on the Environment Bill later. Of course, the policy framework at the moment at a national level remains the same. We've got the NPPF, paragraph 175A. We've got the mitigation hierarchy, so avoid, mitigate, compensate. And biodiversity net gain has really, in truth, grown out of the requirement for compensation approach for biodiversity. And it does really raise the question about whether or not there's going to be a bit more of a shift over to compensation rather than it being used as a last resort. There's an argument to say that in truth that's already happened anyway, but the draft legislation at the moment doesn't make any distinction between how a preference between how you deal with your biodiversity net gain, whether you do it on site or off site. At the moment the legislation treats them equally, and obviously we'll have to keep an eye out for guidance on that point as we move forward. So just looking at how offsetting's been dealt with previously in existing decisions. So the first time that the Secretary of State approved the use of offsetting was a case, an appeal decision, White House Farm in Newcastle. It was for Bellway Homes back in 2013, a case I was involved with. And in that particular instance, the issue was being able to offset for ground nesting curlew. So it was an agricultural site, obviously couldn't recreate that habitat and at the same time build homes, not at the same scale. So at that particular decision, the developer teamed up with the Environment Bank, who you may or may not have heard of. The Environment Bank sell credits for biodiversity offsetting, and that was used as the mechanism to make sure that this offsetting requirement could be met for the ground nesting curlew. So it was quite an important decision, with the Secretary of State accepting that using those purchasing of credits could be a mechanism for securing that offsetting requirement. And as we've already mentioned, of course, although offsetting is part of biodiversity net gain, and I think it's probably going to become one of the most important parts for many people, you can offset, or you can provide your biodiversity net gain on the actual development site. Obviously, it all comes down to how constrained your site is and what your opportunities for improvement are, and indeed, what's the value of the site that you're starting with. So again, where has this all come from? The environment plan is probably where this has all been pulled together. The strands of this were pulled together a couple of years ago by the government. 25-year environment plan, which creates a commitment to a nature recovery network. Now, some of you may or may not be familiar with the Lawton report that was back in 2011. One of the things that looked at was the fragmentation of nature in England. So one of the issues and the reasons, the drivers behind creating a nature recovery network is that effectively what they're trying to do is join up fragmented habitat. And that was an issue, as I say, that was identified 10 years ago. And of course, we're only really getting to the point of maybe being able to do something about it. So the aim is to join up habitat across England. The objective is to create or restore 500,000 hectares of habitat outside of protected sites. So this is in addition to things like triple SIs and special areas of conservation and special protection areas, to make sure that there is space for the natural environment. So what's going to happen through the Environment Bill is that there's going to be local nature recovery strategies that are going to be established. Now, one of the issues with establishing those nature recovery networks is that before, obviously, you can know what it is that you need to do, you need to have a baseline. So at the moment, there is quite an extensive amount of work that needs to be done for habitat mapping of particular strategy areas. Now, the duty and responsibility for carrying that out in local recovery strategies is going to rest with the local planning authority. And of course, on that particular issue, there could be problems with funding. There's a question mark over how quickly that can be delivered, and also whether or not there's the right expertise available to actually deliver this biodiversity habitat mapping on the ground. So we'll have to wait and see how that plays out. But at the moment, there are 5 pilot studies that are underway. So we've got local authorities working with both DEFRA and Natural England to develop baseline maps that can basically be used as an example of pro forma best practice as to how we go about doing this moving forward. So it's a little bit like landscape character area studies in one sense. It's just moving biodiversity planning up to that more strategic scale and actually producing an evidence base so that you can know where it is that you're trying to target your improvements. So that's all being brought forward by the Environment Bill. Of course, one of the things we're here to talk about, though, is the 10% net gain requirement that's being brought through the Environment Bill. The bill is currently at the report stage of the House of Commons, so unfortunately we are not there yet. It was delayed significantly last year in light of COVID, and of course it was hoped that it would actually be brought into effect early last year, but we're way past that deadline now. So in addition to the amendment to the General Duty in the NERC Act, we've also got the imposition of a new requirement for mandatory biodiversity net gain. So every single development that requires planning permission will have to deliver 10% net gain. And of course, has to be remembered that that's not just 10%, it's actually 110%, because you've got to make sure that you match the equivalent baseline of whatever your site was to begin with. The way that the Environment Bill is going to deal with this in terms of the imposition of 10% biodiversity net gain is actually going to be introducing a new section to the Town and Country Planning Act. So effectively what's going to happen is that statute is going to impose a Grampian style condition on all planning permissions moving forward, and that Grampian condition will effectively require a biodiversity net gain plan to be provided to the local planning authority before development can commence, and that's expected to be the mechanism by which the 10% net gain is actually delivered and protected moving forward. However, of course, in my experience, this is not something that's likely to be left just to discharge of conditions stage. You're going to have to demonstrate much earlier on in the process that you can actually deliver your 10% net gain and how you can do that. So the mechanism provided for that in the Environment Bill is the metric. So The bill provides for the Secretary of State to set out a biodiversity metric, a calculator, to work out what is the value of the site that you've got. Then you put your development into it and work out what you're left with, and obviously the difference is the bit you've got to make up the ground on effectively. At the moment, DEFRA's metric is version 2. It is in current use. Many of you may have already had some experience of it. My experience of it highlights the fact that although it is an incredibly useful tool, and this is something that many ecologists have said to me in the course of working on applications together, you do have to take care with it. So, for example, the metric, one of the quirks of version 2 is that it did particularly value scrubland very highly. So that was partly a reflection of how quickly you can establish scrubland on a site. But of course, there was a concern that actually that was leading to less diverse biodiversity plans post-development, because really scrub can only do so much. And trees, for example, were quite undervalued in the metric because of the time they take to establish. So even with metrics, even once that standard metrics in place, approved and has statutory effect, there has to be a bit of a question mark about how black and white the application of that's going to be on a site-by-site basis. Most ecologists that I've spoken to about this over the last year or so have said that it really needs to be a holistic approach. So we'll have to see how that moves forward. We are expecting version 3 of the metric soon. It was supposed to be out in December last year, but it hasn't been published as yet, so we'll have to keep an eye on that. Now, of course, as I've already alluded to, the concept of net gain is very straightforward, but the means by which it will be measured is complex. It is evolving. So there is going to be a need for both developers and local authorities to pay close attention to those developments and keep themselves up to date. So one of the things that has provoked a bit of concern in conversations that I've had with the development industry is the proposal in the draft act to prevent developers from degrading habitats in advance of getting planning permission. Now, I should just pick up as well that the way that the drafting is at the moment, it's not just developers, it's actually any person, so it will include landowners. So as it stands at the moment, they basically are trying to impose a restriction to stop you from intentionally undertaking any activity, and this is an interesting point, any activity that will degrade the biodiversity of the site that we're talking about. Now, at the moment, the relevant date in the Act is suggested to be the 30th of January 2020. I think that's something that's probably just got lost in the drafting, given the previous timescale that the Environment Bill was expected to be introduced by. There's been no suggestion or comment that this is really intended to have retrospective effect. So I think hopefully that will be picked up as the bill moves through the House of Commons and onto the Lords. There's a question mark, though, about how do you deal with it, with the situation where, for example, you've got an option on the site and it's an existing agricultural, in existing agricultural use. So it needs to be managed to make sure that that agricultural use can go forward. Things, as we'll all be aware of, things like, you know, flogging hedges and trimming things back and, you know, making sure that fields can be ploughed. Now, on the drafting at the moment, they would fall within the definition of any activities, and it kind of suggests that what you'd need to do is go and get planning permission for agriculture, which of course is completely contrary to the whole statutory framework in the Town and Country Planning Act. I think that's something that's going to have to be picked up through the drafting process. I don't think it's intentional. So, you know, hopefully the legislators will take that forward and reconcile it. But it is something to look out for. And it also highlights the importance. If you are looking to sign up a site, even at the option stage, you need to be thinking about what's your baseline evidence for the biodiversity value of the site at that time, because obviously that's going to be your benchmark. And that's the best way to protect yourself moving forward, is to make sure you've got that evidence base locked down so that you can rely upon it moving forward. One of the other relatively novel concepts in the Environment Bill is the idea that not just do you have to provide 10% net gain, but you also have to effectively maintain that net gain for 30 years. So a 30-year maintenance requirement. Now, I say relatively new because actually any of you who have experience with the minerals sector will understand that that's something that's quite common on aftercare provisions for that particular type of development. But of course, they're very different in nature because the operators will tend to have a long-term interest in their sites, which means that they can, in fact, deliver a 30-year maintenance requirement and they can manage it themselves. Now, at the moment, what's not clear is how that will work in practice for other forms of development. So if you've got housing, for example, and you've got plot sales, where does that responsibility fall in terms of 30-year maintenance requirement? And how is that going to be dealt with in things like Section 106 agreements? Obviously, we've already got issues where we're having to set up development management companies to deal with things like open space on development sites. Is this going to go the same way? Obviously, if you're offsetting, this issue is a little bit more straightforward, depending on the offsetting approach that you're using. If you're paying credits to somebody like the Environment Bank, then it's obviously that the 30-year maintenance obligation will effectively fall on them, but you'll still have to pay the extra. So it's going to have a financial impact. And I think one of the things that this 30-year maintenance requirement will do is really give a boost to this market for offsetting with accredited providers who will effectively sell credits to developers for them to buy. Now, it's worth just bearing in mind that at the moment, although it's not mentioned directly in the draft legislation, it has been trailed that there will be a 2-year transition period once the Act comes into force until mandatory net gains actually become a requirement. So we'll have to keep an eye on how that moves forward. But there will be, hopefully, there will be some time for developers to understand how they can deal with this. You also need to bear in mind that, of course, the 10% net gain doesn't preclude or remove the requirement to deal separately with the legislative protection for European protected sites, or whether they'll be called European moving forward, who knows, now that Brexit's taken effect, and protected species. So you do need to bear in mind that you can't just forget about those and say, well, it's okay, I've done my 10%. No, you still need to think about your bats and your newts and whatever other protected species come our way as the government works its way through what it wants to do post-Brexit. So I'm then going to hand over to Emma Conwell just to talk you through conservation covenants.
So conservation covenants are going to be the method of actually of entering into the obligation and also of enforcement for these maintenance period of 30 years, which is suggested, or the ring fencing of land for biodiversity net gain. So these covenants are, on the current drafting, very similar to Section 106 agreements, but they will deal with conservation only. So it can contain covenants which are positive or restrictive. So, for example, not doing something to secure a conservation outcome, or doing something such as maintaining the land for 30 years. Just like 106 agreements, they'll bind successors in title, and they will apply for an indefinite period unless a shorter period is agreed within the actual covenant agreement itself. The interesting thing about these conservation covenants is not necessarily what's in the detail of the current bill, but the consultation responses to that actually were carried out prior to this being included. So conservation covenants are largely used at the moment in areas like America and Australia. So we have those countries as examples at the moment. And from that, one of the key questions that arose from the consultation period was whether there would be a standard form conservation covenant that could be used on all sites. And the government indicated that that might be a possibility, but what seems to be more likely would be that each individual body would have its own conservation covenant, which would then be tweaked to apply to each individual site. but we wait to see if that actually happens, because at the moment the drafting of the bill doesn't cover that. It might come forward from regulations, but we'll wait to find out. Additionally, the other interesting point is whether a third party, so in these conservation covenants will be entered into by a landowner and a regulatory body such as Natural England. So the bill doesn't cover at the moment whether a member of the public could enforce against Natural England for not properly monitoring or not properly enforcing against a landowner or developer for not carrying out the covenants in the conservation covenant. There are some issues which are not dealt with by the bill at the moment that we're going to have to wait and see whether regulations provide further detail, or wait to see what comes out from a practical perspective once these conservation covenants are entered into. So there is scope to vary and discharge the covenants, and similar to 106, that would be a deed of variation to amend what's happening. So at the moment, the future of Section 106 agreements is quite uncertain, and we'll touch on that in the next few slides. But what seems to be more likely is that these conservation covenants will also sit beside a Section 106 agreement. So the conservation covenant might cover the monitoring obligations, but a Section 106 agreement might be required for other specific, more nuanced issues on each individual site. The fact remains to be seen whether that will be the case because of the uncertain future of Section 106 agreements. I think if you have any questions, let me know, but that basically covers what is covered by conservation covenants in the bill at the moment. I'll hand over back to Alison now.
Thanks, Emma. Just move on to the next slide. So just to run through some sort of more practical considerations, Emma's already alluded to, how does this get delivered? What's going to happen to Section 106 agreements? There is a big question mark over that at the moment, and unfortunately it is a little bit watch this space. My opinion is that I think Section 106 agreements will still end up being used for things like this, because even with conservation covenants and biodiversity net gain conditions that the Act is proposing, I think there will still be a need, as Emma suggests, for more nuanced approaches on particularly complex sites. So we'll have to wait and see how that plays out once we're up and running. So just to flag up then, firstly, that schemes where a biodiversity net gain is already inherent in proposals should be promoted as such to local planning authorities. And at the moment, obviously, we don't have mandatory 10% net gain. The Act is not in force. We're expecting a 2-year transitional interval, so you can try and use that as a real benefit ahead of any mandatory requirement. And just on that, there was a decision appeal last November in Milton Keynes, where a local planning authority was trying to suggest that it could require a 10% net gain in advance of the Environment Bill, and the inspector rejected that argument and said, no, your policy at the moment, it requires net gain, but it doesn't say how much. So you can't have the full 10% because it's not actually required by the policy, and the Environment Bill is not yet law. So, do bear in mind, which I know Paula will come on to in due course, what the local plan policy actually says when you're having a look at what's required to deal with biodiversity net gain in the interim period. You do need to be thinking about how your strategy is going to develop for longer term sites. So anything that's going through local plan allocation at the moment, for example, if you're entering into option agreements, this is something that you really need to be looking at the front end of decisions about what development is going to go on a site and how is that going to affect, for example, the financial viability of the development. So you need to be planning ahead for biodiversity net gain. You need to be making sure that you collect your evidence and you need to ensure that you establish that baseline so that you are not unduly penalised with your 10% moving forward. The other thing to consider in terms of planning ahead is whether or not you can put any other mechanisms in place to try and effectively have your own land bank for offsetting. Now, this is something that quite a lot of the development industry is having a think about at the moment. there's expected to be quite a big boom in market for providers for offsetting on other sites. They could either be local or they might be national. At the moment, there's no actual policy that says you can't use national offsetting, but generally speaking, for obvious reasons, local planning authorities are highly likely to want to have offsetting within a certain physical proximity to the area where that actual biodiversity is being lost, and that's certainly the approach that's more likely to be taken at the moment. Now, there's no hard and fast rule on that. It really comes down to, well, what is the habitat that you're losing, and how does that fit in with where you are, what the physical constraints are of your site, what's the rest of the district like, for example. It might be that you're not that far away from a particular strategic piece of green infrastructure, and that could be an obvious way to deal with offsetting and your biodiversity net gain. But every case is going to have to be considered on its own facts. But can you deliver it yourself? One of the advantages of that is that you're not going to be at the behest of the market. At the moment, a biodiversity credit, which is the thing you have to buy to be equivalent to your biodiversity unit that you've got to make up your 10% with, they're expected to be between £9,000 and £15,000 each. That, of course, could fluctuate. So if you're trying to future-proof and obtain some certainty, one of the things to think about is to see whether or not you can actually do that with land you control yourself. And of course, as Emma's already mentioned, conservation covenants are one mechanism that might allow you to do that. I mean, my own view is that I do think they are quite... the setup of them at the moment in the Act is quite cumbersome. It seems quite strange because ultimately there'll be a local land charge, and therefore they have to be enforced by the local authority who has the land charges registry, but they might require lots of other different parties to be involved in them, and then you're going to be relying on the local authority to enforce against, for example, perhaps a local wildlife trust, depending on what that particular conservation says. So I think there are going to be, teething problems at the very least with that particular solution. So just picking up very briefly on the white paper, which I'm sure you'll all be familiar with, obviously there's some quite radical proposals in there for what planning will look like in the future. And one of the things that has been mentioned is that Section 106 agreements will be replaced with a new infrastructure levy. Now, the detail on that is very light at the moment, and very little has come out since the white paper to flesh out the bones. So it's the question of how does that work? How would an infrastructure levy deal with securing non-financial obligations and off-site mitigation? Will conservation covenants be enough? Will the biodiversity plans that have got to be secured by what seems to be a statutory Grampian condition on every planning permission moving forward, will that be enough? Or will there still be a gap where you really do need to use Section 106 agreements? We'll have to wait and see how that transpires. But of course, it's difficult to see how the infrastructure levy on its own could deal with that, and certainly how it couldn't seemingly secure 30-year management plans and maintenance payments. So again, that's one thing that we need to keep an eye out for. So I will now pass over to Paula to give us the lowdown on biodiversity net gain from a planner's perspective. Thanks very much.
Thanks, Alison, and good morning to everybody. My name is Paula Carney. I'm the Joint Managing Director of Carney Sweeney Planning alongside Jed Sweeney. We act for developers and landowners right across the UK in tight urban sites through to large-scale estate owners' land. Dealing with issues, a wide variety of issues, including biodiversity, which is obviously gaining more traction as time goes on. So, as Alison says, we're going to be working with our clients to ease them through and direct them through the maze of biodiversity net gain as it's rolled out. in advance of the Environment Bill becoming law, policies are already in place in some development plans and being applied. And in the future, further to the white paper, we're expecting that these may be replaced by standard national policies. But currently, the development plan policies are the first place to start. They have primacy, and there are different approaches and emphasis of development plan policies throughout the UK, which I'll run through. Not to be biased to particular parts of the UK, and we've got examples from right across, from north to south, including the Midlands and including London. Now, the policies that are in place in development plans at the moment focus on two different areas. One is where there's impact on protected sites and the application of the principles of avoid, mitigate and offset, and the application of planning balance. And the second type deal with the enhancement of biodiversity as part of development proposals, i.e. the net gain principle. And as we talk through some examples of the policies, you'll see that some policies require net gain and some seek it where possible, and various other forms of wording. So it's important for every site that you're dealing with that you look specifically at the development plan policy that's relevant to your site. And as policies are part of the development plan, local planning authorities and the inspectorate are giving these policies weight in advance of the Environment Act coming into force. And I'll run through some examples of appeal decisions in this regard. So firstly, looking at Warwickshire. This policy in the Warwickshire Plan requires use of the Warwickshire Biodiversity Impact Assessment tool, which is a local metric to establish the biodiversity of a site before and after development. And that works out how you can calculate what the residual biodiversity loss and what biodiversity net gain is required, and how then that can be brought into force, whether it's offset on as part of an offset agreement on another site, or by making a financial contribution. Looking at Barnsley, the local plan from 2019 contains a policy which lists ways in which the development will be expected to conserve and enhance the biodiversity and geological features of the borough, and includes an expectation that development proposals will follow the avoid, mitigate, compensate hierarchy, and then development which may harm a biodiversity feature will not be permitted without following that hierarchy. In Plymouth and South West Devon, again a policy from 2019, seeks proportional biodiversity net gain from all major developments. Note the major rather than minor in this particular policy. Level of biodiversity net gain required will be proportionate to the type, scale and impact of development, which again is a slightly different nuance. An enhancement for wildlife within the built environment will be sought where appropriate from all scales of development. So again, note that will be sought and then appropriate from all scales of development. So, and it's the way that this authority is approaching it is that net gains will be expected to support local schemes for improving biodiversity and a local action plan being in place. And again, the provision of long-term management of biodiversity features. Looking at Runnymede, and take note of this policy because we're coming on to some case law in Runnymede in a moment. There's two parts of this policy. The first establishes that development proposals should demonstrate how they will achieve net gains in biodiversity, and a number of different ways they can do that through creation, expansion, restoration, enhancement and management of habitats and features. And then the second part requires that development proposals affecting protected sites will only be granted where it can be demonstrated that the benefits of the development proposal outweigh the harm, and then you're following the hierarchy of mitigation. Looking at the New London Plan, the version from the draft version from December, there's a protection of sites of nature conservation. That policy specifies that development plans should establish coherent ecological networks and identify deficiencies, which again we'll come on to in a moment, which again is a slightly different tack. Protect and conserve priority species and habitats, promoting the use of biodiversity action plans, promoting habitat creation, and that local development plans in London should designate sites of nature conservation importance. There's a mitigation hierarchy established where harm to sites of importance to nature conservation is unavoidable, and where benefits clearly outweigh the harms on biodiversity. So again, that planning balance requires that development should manage biodiversity impacts and aim to secure biodiversity gain to be addressed from the start of the development process and schemes. And it refers there to the local environment strategy. So again, different emphasis with regard to requiring and aiming and looking at deficiencies. So that's we've got the Lambeth Local Plan, which is currently awaiting the inspector's report, which is being prepared having regard to the approved London Plan, and obviously with a nod to the new London Plan, which is coming forward. And policy EN1 within that plan seeks to prevent development which would result in a loss, reduction in area or significant harm to nature conservation or biodiversity value of an open space, including, so it's not just dealing with identified sites, but dealing with all open spaces, unless adequate mitigation or compensatory measures are provided. And then it requires development proposals, but then it says wherever possible to protect, enhance, create or manage nature conservation. So again, slightly different use of language. Talks about obligations for open space improvements to include biodiversity value, and development should contribute to the creation or extension of green corridors with biodiversity value. And then it talks about the Biodiversity Action Plan as a supporting document. So you can see the various different nuances of policy. So it's really important that you read your development plans policies properly when considering development proposals in those areas at the moment in advance of the Environment Act. So just looking at some case law examples quickly before we move to answering some questions. There's a case law example here from Weymouth, which is very up to date from December 2020, where weight has been given to the supply of shortfall of housing, engaging paragraph 11D, and the benefits of providing housing outweighing harm to a rural conservation area. Also to note, the council had declared a climate emergency, referring to the creation of high value ecological areas and planting trees. The inspector considered the loss of on-site trees would conflict with these aims, and that the biodiversity impacts would be mitigated rather than the existing habitats fully preserved in situ. The inspector concluded that this must be balanced against the need to provide housing and the environmental and social benefits of doing so. So he therefore considered overall that biodiversity considerations had a neutral consideration that then when applied in terms of the planning balance. So coming back to a case in Runnymede, which I talked about earlier on, and the application of that policy EE9, This site was in the zone of influence of an SPA. SPAs, for those of you who work in this area, are very relevant in these particular areas of Surrey. It was concluded that recreational activity in this area would impact on the SPA. Natural England and the local planning authority here have established mitigation measures in place, and therefore a financial contribution would mean that there wouldn't be a conflict with policy EE9 in relation to the SPA. However, because of the two forms of biodiversity that are taken into account in policy EE9, it's not just about protecting the SPA and biodiversity in that regard, but having regard to biodiversity net gain. And in this case, the inspector concluded that there wasn't biodiversity net gain in accordance with policy EE9, and therefore it conflicted with those objectives. Moving on to a case in Devon from October last year. This is looking at offset. This dealt with agricultural buildings in the AONB countryside and the undeveloped coast. The inspector concluded that there was no harm to those designations. And this case is interesting because this was an offset site and was supporting a site purchased in June 2019 with the intention of improving its biodiversity and establishing a rural business based around produce from the land. And that was supporting another development site elsewhere. So hopefully that's given you a flavour of things to consider in advance of the Environment Act coming into force, which we imagine will be sometime this year, who knows when this year. But so hopefully that gives you an insight in what to have regard to now, and picking up what Alison was talking about and Emma earlier on, what is to come. So it's definitely a big issue going forward in 2021. So I'm going to hand back to you, Emma, just to talk about the questions coming in and giving answers to those.
Yeah, so we've got a couple of questions come in. I think the first one's probably on Alison's information. So Alison, one of the questions is there a minimum threshold of units at which 10% biodiversity net gain is required? I think that says, sorry, I'm struggling to scroll down on that box.
No, that's all right. I think I know the one. I've got it up as well. Thanks, Emma, and thanks very much, Paul. That was really interesting to hear about all the different policies, because you're quite right. At the moment, without the Environment Bill, ultimately this issue really has to be looked at an area by area basis, depending on what the development plan actually says. And they are all slightly different, and they all do have different nuances. But coming back to the question, in the Act as proposed, the draft bill does not have a minimum threshold for 10% net gain. Now, whether or not that will be thought about as the Act moves forward and in statutory instruments that move on from the Act and provide extra detail, we can only watch and wait. But as it stands at the moment, there isn't a minimum threshold. And of course, there is a bit of an issue about this in terms of, well, what will the Act do to the planning balance, and how will this fit together in future decisions? So the appeal decisions that Paul has just mentioned, for example, where obviously there's an ability to weigh the need for delivery of housing against the need to deliver the 10% net gain or some net gain and biodiversity generally. Ultimately, it's got to be expected, given the Act, that the statutory force of that instrument is going to start changing the planning balance quite markedly. So you won't be able to sort of say, well, it doesn't matter on this particular site, we can only do 5%, or we can't do it because it's not financially viable. So it is going to quite radically change things.
Thank you. So the next question is about conservation covenants and who, sorry, everything's flashing on my screen. I have no idea why. Who a responsible body is expected to be, and at the moment, a responsible body is expected to be a conservation organisation or possibly a charity, for example, a wildlife trust. they will be designated by the Secretary of State in future regulations. So at that point, it will become very clear who can enter into these sort of agreements. The third question, I think, Paula, is regarding policy. And it says that the B&G policy examples and local plans don't seem to provide a lot of practical implementation guidance. Is additional guidance given in SPD?
It varies from authority to authority, as you would expect with all different authorities and all different development plans. Some have got practical implementation guidance in the text of the policy. Some have got SPGs, some have nothing. There's biodiversity action plans which look to assist. And then there's generally case law examples, whether that's by appeal or whether that's by just precedent of decisions in an authority that you would need to have regard to. Every authority is different, so it's not a case of one size fits all. It's really important to get under the cover of the way that it's being applied and the nuances of practical implementation in each borough. And I think the longer that those policies have been in place in a particular borough, clearly the more experience that the local planning authority have got of dealing with things and the more precedent examples that there'll be.
Yeah, I absolutely second that at the moment, Paula. I mean, there's also a related question about whether or not it's appropriate for local planning authorities to be applying Biodiversity Net Gain now, or is it premature? Well, and an indication that there's a mixed bag being experienced. And I think the answer to that, the reason why there is a mixed bag, is because some authorities do have policies in the development plan that allow them to ask for it. Whereas others are way behind the curve, depending on when they last adopted their local plan. And of course, Paula, you've already given the examples of some of the authorities that do have those biodiversity net gain policies already. And my view would be, which the inspectors are clearly reinforcing, is that if they've got a policy, they are required to. That's perfectly within their purview to require it well in advance of the Environment Bill. The question is how much, where, what type, and all of those other more, as you say, nuanced issues that come into that interpretation of policy and the wider planning balance in the intervening period until the act's in force. I mean, is that your take on it, Paula?
Yeah, definitely. It's, the primacy of the development plan. That's the way that the law is at the moment. And therefore, if there's a development plan in place, it's important for that to have regard to that development plan, and inspectors are applying those development plan policies in advance of the Environment Act. And I think the example that you used right at the beginning, Alison, where you were talking about is 10% appropriate, as I understand it, in that development plan didn't talk about 10%. They just talked about biodiversity net gain. So biodiversity net gain in principle, yes. 10% no in advance of the Environment Act. It's just important to have regard to the policy and not try and enact the Environment Act before it actually comes into force.
Yeah, absolutely. There's also been some questions about baselines and capturing baselines. There's a question about whether or not there's a specific requirement to manage habitat, to maintain a baseline. There's nothing about that in the Act at the moment. What the Act's trying to do is make sure that positive activity doesn't happen to degrade a baseline, not that once you've got a baseline you then have to go and spend money on it to make sure that that's maintained. So I think there's going to be a distinction moving forward, depending on how that develops, between activities, something that you are positively doing, and an emission. So you just leave that site and you let it go. The problem, of course, as you'll all be aware of, is that if you do leave a site unmanaged, then it tends to get more biodiversity value, not less. So that's probably not something that you're going to want to do if you're looking about future-proofing the site for development prospects moving forward and trying to minimise how much you might be paying out for offsetting contributions in due course. There is a related good question about how do you establish baseline evidence for biodiversity on the site. There aren't any hard and fast rules about that at the moment in terms of exactly what it is that you would do, but my advice would be at that stage of the game, you get your ecologist involved, you get your initial ecology appraisal done on site, so you know what habitat you've got. And then ultimately, it depends how far you want to go, if you're at the stage where you're only signing up an option or you're promoting through the development plan, but you might want your ecologist to run the metric for you so that you know what that value is, and you, at least financially, you know where you stand in that regard. But in terms of establishing the baseline to make sure you're protected from any allegation that you made it worse or something happened to it once you got involved in that site, it's really all about, ecologist reports and site surveys.
There's also a question being raised about viability assessments and conservation covenants, and obviously it's commonplace at the moment. The Section 106 Section 106 agreements for viability assessments to be included. The current bill doesn't deal with viability for biodiversity net gain, so it's not likely that that's going to be included. And the reason that I say it's unlikely is because that is one of the key issues with Section 106 agreement that the government are raising. That is one of the reasons that they want to abolish the current Section 106 process. What I would say on that topic is that the bill does allow the Secretary of State to provide regulations for anything additional to be included in conservation covenant. So if this becomes a particular hindrance to development, it might be that issue is revisited and addressed, particularly given the government's position that they want to build with as little red tape as possible. So.
Yeah, I mean, there does seem to be a conflict, doesn't there, at the heart of that, Emma, in terms of the two things that the government's trying to achieve, bigger, faster, quicker, more development, better environment, more ecology, more diverse biodiversity, and the two are, they do slightly pull in different directions, and it's going to really, the proof's going to be in the pudding to see how this all connects up together and moves forward.
I think that's apparent throughout the Environment Bill, that tension, but also in statements by ministers that have been given recently. Obviously, they've said that Brexit will be a green Brexit, and that environmental protections will be just as tight or even more tight than they are under the EU. But at the same time, you've got the Prime Minister saying, we just need to get these houses up, we need more affordable housing, and generation rent will end. So it's definitely a confusing position that the government are putting forward at the moment.
I mean, is that something that you're experiencing as well, Paula, on the planning side?
Yeah, I think politically each authority has a slightly different tack on this. It really depends on the politics and the emphasis and the main attitudes and emphasis in a particular authority as to how they're approaching it, to be honest. Although, having said that, I think it is becoming a bigger and bigger issue. So more regard is having had to it generally. But as I say, the application and emphasis is slightly different in each borough, depending upon their politics as much as anything else.
Yeah, I mean, I think you're right. I mean, politics is always going to play a big part, and I guess that's probably feeding into some of the inconsistency as well that clients are experiencing on the developer side at the moment between authorities, because, ultimately it really depends what the driver is for that particular local authority. There's a question about whether or not there's anything to stop local planning authorities asking for the most expensive credit cost in terms of buying credits for offsetting. there isn't anything to stop them as it stands at the moment, but there's also nothing to require it. So, my advice, if you're in a situation like that where you are negotiating with the authority about what the appropriate financial contribution is, or which credits you have to go and obtain, what is it that you actually need to replace? It really comes down to a site-by-site assessment of what is the habitat that you're losing, and then what is it that you need to actually go and get to make sure that you're offsetting the same kind of habitat that's being lost. I mean, ultimately, it's not always the case that every authority will insist on equivalence, so that you've got to replace like with like every single time. But that is a theme that I've certainly seen in local authority approaches. But no, there isn't anything sort of black and white that sets out the rules on that at this stage. Ultimately, we're still early days. I don't know if you've come across anything on that, Paula.
No, not especially. I think it is early days. I think everyone's feeling their way, most definitely. I think some authorities are better equipped to deal with this than others. Some have, there's a question here about resourcing up to deal with management of obligations, but also it's equally applicable to application of policies and biodiversity plans. Some are taking people in-house, some are relying on third-party consultants. I imagine, as with Section 106 monitoring costs and what have you, there will be an element in the biodiversity net gain attributable to the obligation costs for monitoring that going forward. And then whether they'll deal with it in-house or whether they'll appoint a sub-consultant to deal with it. It'll be interesting to see going forward. I suspect it'll vary borough to borough, but I think much depends upon how local authorities are prioritising it and how much money they're investing in resourcing and consultants, really.
Yeah, absolutely. And I think the extent to which it becomes standardised, really, we won't know about that, I think, until the Act is actually brought into force. We've got regulations that flesh out the details, and then we've got guidance that follows on, because one of the other issues that arises is that the Act provides for the DEFRA metric, or a metric that's going to be basically brought in by the Secretary of State, for example, which we all expect to be the DEFRA metric. But as we've already heard, there are other authorities already using local metrics. So it's a question of how is that going to fit together. It seems at the moment that there's going to be a preference for the standardised approach, but will there be any wriggle room? Will there be any ability for flex? And obviously we've also got British standards looking at biodiversity net gain and producing a methodology for how that might work on the ground. So it's a question of how is that going to sort of factor in and follow through. But all of these things, unfortunately, at that stage on these particular issues, there's probably more questions than there are answers at the moment. I think we're running up against the buffers on time. Is that right, Emma?
Yeah, I think we're coming to an end now. So I'd like to say thank you to everyone for listening and all your questions this morning, which have been very interesting. What we will do is we'll make a note of all of the questions, and we'll try and come back in our response. What we'll do probably in the next couple of days is circulate the slides, circulate a video recording, and we'll try and answer those questions that we haven't touched on. In the meantime, if you could give our Walker Morris planning page a follow on LinkedIn, that would be really good. It can give further updates on biodiversity net gain and the Environment Bill as it progresses through Parliament, so that might be helpful. And feel free to get in touch with Alison, myself, or Paula if you do have any further questions on what we've discussed today, or are looking for any specific advice on biodiversity net gain. I'm sure we'd be more than happy to assist.
Absolutely. Thanks very much, everybody.
Thank you. Bye-bye.
Thanks. Bye.